You're starting to get notices from the credit card company. They want immediate payment of those charges you ran up, and you don't have the money. So what can you do? Should you try to call them and work something out? Or suppose you won a judgment against somebody else. How can you get what's owed to you? Our phone number is 404-815-3030. A show about collectors on the Layman's Lawyer, coming right up.
Major funding for the Layman's Lawyer is provided by the Georgia Civil Justice Foundation. The foundation publishes a free quarterly newsletter to teach you about our legal system. The foundation's telephone number is 404-522-2744.
Hi, I'm Dennis O'Hare. Welcome back to the Layman's Lawyer. Uncle Sam is not the only one paying off a lot of debt these days. It seems we all are. And when we can't, companies like the ones that sell us credit cards or cars have a lot of legal tools to help them get their money. If you've got a judgment against you, what can happen? And what are your options? Or if you've won a civil court money battle with someone, how can you collect? That's our show tonight, Collecting. Our phone number is 404-815-3030. Attorneys are here to take your calls, and they'll help you out. And we will talk to some of you live in just a few moments. With us tonight, Jay Loeb of Olim and Loeb and Harriet Isenberg of Isenberg and Hewitt. Welcome to both of you. Nice to have you.
Nice to see you.
Mr. Loeb, let's start by assuming you're the person who owes the money. And you start getting those letters from the car finance company or from your store. Maybe you have a credit card with a store or the credit card company, whatever. You probably figure, hey, these folks send out a lot of them. They probably won't follow up. Is it smart to just ignore them and hope they'll go away?
I think it depends upon whether you just have one particular debt that you're behind on or whether you have several debts that you're behind on. Normally speaking, you're going to start getting collection dones. That's writing. If you miss 2 consecutive payments on any type of credit card obligation or account obligation. And if it's just that one particular obligation, and that's the only problem, then I think it's wise to call up that particular creditor and to arrange some type of smaller payment arrangement with them.
Now, that's something that most companies will do pretty willingly as opposed to just coming after you? They'd rather hear from you and work it out?
They'd rather hear from you and work it out, and it's much more likely to have a workout situation if it's from a bank or an institution outside the state of Georgia, where it's more expensive for them to have to hire somebody to come collect it.
Okay. What if you dispute that you owe the money in the first place? I mean, let's back up one step. You get a notice and you say, hey, I don't owe that. What happens then?
Send a writing to them, preferably a certified mail return receipt requested, that you dispute owing that particular debt or owing a particular amount of that debt. And then they have an obligation under federal law to investigate the bona fides of your particular claim and not to charge you any type of finance charge on the amount in dispute.
Okay.
And then they're supposed to get back to you on your particular dispute to determine whether or not it's a bona fide defense, claim, or offset.
Okay, let's assume then that if you're not disputing it, and everybody agrees, yeah, you owe the money, or at least most of it, when you're working things out, is it possible or is it even customary to work it out that you end up paying less than the amount you owe just to get it settled, and they'll write off the rest somehow? Does that happen a lot?
It happens more than you think.
More than I'd like to admit, I suppose.
And again, I think a lot of it depends if it's one particular debt or if it's more than one debt. I mean, if you've got 5 particular credit cards over $25,000, they can easily run a credit check on you, see that you're behind on the 4 other ones other than them, and that you have a bona fide financial emergency. On the other hand, if it's just one particular credit card and you say, I can't pay that minimum finance charge of $225 a month, you're going to have to come up with a pretty good reason, an unexplained medical situation that wasn't fully covered by health insurance, one of 2 wage earners has lost their job, something like that. And then, of course, always mention the specter of bankruptcy, and I think many times they will then listen to you and negotiate a lesser payment situation.
Ms. Isenberg, is there a step that often happens before you go to court? I mean, you've talked to them, maybe they haven't worked things out. can you expect, before you get actually a lawsuit, can you expect some sort of nasty lawyer letter to come in the mail?
Well, I think most attorneys that handle collections will send a 10-day demand letter. In fact, in some cases, it's legally necessary. And what happens a lot of times is the debtor receives a certified mail, and I think, oh, if I don't claim it, then I didn't get it. But
if
that's
I pretend like I didn't get it, then I really didn't.
But the law says if you don't claim it, you're assumed to have received it. So you don't solve anything.
All it has to do is get there. You don't have to actually accept it. And
right.
if it gets there, then you got it.
And so you're better off to open it and find out what it's about and try to resolve it than to ignore it. And I think that's the biggest problem, is people just try to ignore the things and think they'll go away.
You get a demand letter. Do you have a certain period of time to respond before they can file suit against you?
Well, there's a 10-day demand letter that's common, and you know, in some situations it's required that you give a 10-day demand letter.
Okay, now if they file suit, I mean, where does that usually happen?
Well, if you don't respond to the letter, then in a suit is filed. It's where you live generally. If it's an individual, if it's a business, it can be a few other places, but generally it's where the person lives, and it's in either the magistrate court or state court, in some cases Superior Court.
The magistrate court is for debts of like $2,500 or less, something like that?
5,000.
5,000 or less. Okay. Other than that, you're into state court or even Superior Court?
Well, you can be in any of the courts except for the magistrate court on any amount. I mean, you can file in Superior Court or state court.
Does it make any difference practically, though?
Well, a lot of creditors want a quicker result, and they'll go to magistrate court. I think the state courts are the busiest with respect to debt collection, I think, in this state, and I assume other states too. I don't know. Okay.
I'm sorry, Mr. Loeb, you looked like
Dennis,
you were going to say something.
Yeah, I think we ought to back up.
Okay.
You start with that notice or done from the company that you dealt with, which we call the creditor.
Okay.
And then particularly if it's from somebody out of state, they'll first refer it to a collection agency to try to collect before there'll be any lawsuit filed. So I'm just trying to say is usually have a good 6-month period of time from the time you missed a payment at the earliest before there'll be any lawsuit filed against you.
A lot of people say there's probably, or have heard that there's probably a way to keep the collection agency from coming at you again and again and again with phone calls at strange hours of the night, that sort of stuff. Is there a magic set of words you can say to tell them, go away, or if you want to talk to me, go through my attorney?
Yes. As long as it's referred to a third-party collection agency and not just the collection division of that particular creditor.
Okay.
All you have to do is send them a writing saying, do not contact me about this debt. I don't want to hear anything more about it. I just, nothing about it. And they are not supposed to contact you anymore, or it'd be a violation of federal law.
Now that, again, it's real important to make the distinction here. That's a third-party collection agency, right?
On a personal or consumer debt, not on a commercial debt.
Okay. Now, they can still come after you or still contact you if they are the collections division of the very company to which you owe the money.
That's correct.
Okay. Now, the other thing is that even if it is a third-party collection agency, and even if you do send them the magic letter and they stop contacting you, that won't stop them from trying to collect, right? I mean, they'll
stop
still
them
sue
from
you.
Harassing you.
Yeah.
It does not stop them from suing you.
Yeah. Okay. Important
but again,
to remember
many
that
times that has to be referred then to like a Georgia attorney before a lawsuit can be filed. In other words, a collection company out in Nebraska is not going to do anything to sue you in Atlanta, Georgia. They have to hire somebody in the state of Georgia to do the actual suing.
Okay. Now, let's assume they've done that, and you've gotten the demand letter, let's say, and you haven't been able to work things out. It's gone to court. What's the process here? I mean, what happens?
Harriet, I think you wanted to handle that.
Well, you'll be served with a lawsuit by either the sheriff or the marshal, depending on which court it is. And when you get the lawsuit, you're required to answer it within 30 days. If you fail to answer it in 30 days, you'll get a default judgment against you. And I would urge that people not ignore it. We get a lot of defaults. I say more defaults than people answering. And I think if they ignore it, again, it's going to go away. It doesn't go away because the next thing that can happen is once you get a judgment against you, then they can garnish your wages or come and
even
seize
seize some of your assets.
Well, they can come seize your property, and And there's a lien against you. You won't be able to get any credit, or you won't be able to, buy a car or sell your house. Or it's pretty serious if you get a judgment against you.
So what happens in court? Let's say you're not going to ignore it. You're going to go to court. But what can you expect to happen there? What is it? Is it, for instance, is there a jury, or is it just decided by a judge? Can you get up there and tell your own story, or do you need a lawyer? What kinds of things are good to have?
I would always recommend that you have a lawyer because you're going to be up against a lawyer who knows the law. Mm-hmm. And if you go into court and have no idea what to say, what to do,
you're at a big disadvantage.
You're going to lose because you don't know the law. Mm-hmm. And chances are you don't have much of a defense anyway. But a lawyer sometimes can think of one. They can look at the document and say, wait a minute, you don't owe this. You don't only owe this much. And so they can help you respond to the lawsuit. But it's important that you do respond and not ignore it.
Now, who has the burden of proof? Is it the person coming after you, or do you have the burden of proof to show, well, I don't really owe this?
Well, the person coming after you has the burden of proof, and they have to show that you owe the debt and how much the debt is, and prove the debt to the court's satisfaction.
Do most cases, though, even after the suit is filed, do most cases settle before a trial with, let's say, a consent agreement or something like that?
I wouldn't say most, but that's certainly a desirable thing for both sides. It certainly spends less money, and it gets money coming into the creditor quicker than waiting for court. You could wait sometimes, a year or so to go to court. In the meantime, that you could have, a pretty good recovery if somebody was paying some monthly payments. And I would say, that's a good way to collect the money and a good way to pay only what you can afford to pay. You just convince the creditor's attorney that you can only afford to pay a certain amount a month, and very often they'll say, well, that's better than nothing. Than nothing.
Yeah. And Mr. Loeb, I think a lot of people on both sides of this don't realize this. Fighting this stuff out can get really expensive, so there's a lot of pressure, probably on both sides, to settle one way or another, right?
Well, again, the creditor wants money. Mm-hmm. The debtor usually does not have the sum of money that the creditor has sued for in a lump sum payment. So there's an incentive on both sides to try to settle, and that's why I joined in what Harriet was saying, and immediately contact that creditor after you're served with the lawsuit. And assuming that there is no dispute as the amount owed, try to negotiate some type of payout arrangement with that particular creditor that you can afford and also pay your other bills. It doesn't do you any good to agree to pay that particular creditor $750 a month and not leave enough money to take care of your other obligations, or you're just going to be in a problem with two other creditors 6 months thereafter. And what you can do is enter into a consent order rather than a judgment, where there is no judgment entered against you. There is no 5A filed in the real estate records that becomes a lien on your property, so long as you make those payments as you agree to, say at $125 a month. So I think that's another reason why you want to contact that particular creditor, because before that judgment's entered, the debtor has some bargaining leverage.
Do you have leverage even after it's entered? For instance, they now have a judgment, but they still have to collect. They don't want to go through a hassle in collecting. Even afterward, do you still have some leverage?
I think it depends if that particular creditor knows whether you have a job, that your paycheck can be garnished, or they know where you bank. If you're a self-employed individual, it's usually very hard to collect from them. And I'll let Harriet give her comments about trying to collect on that particular judgment and where the leverage is. But the best time to talk and resolve the situation is after that lawsuit is served, and assuming there's no dispute as the amount owed, that's the time to talk to the creditor, get the payout arrangement, and get it in a consent order, not in a judgment. Not in a judgment.
If you're the debtor, a consent order is a lot less heavy on you in terms of your record.
That's correct.
Okay.
Well, actually, the consent order never becomes a judgment in most cases unless you default on it. So that means that once it's paid,
it's kind of like a contract instead of a judgment.
Exactly. Right. And it's just like a case is dismissed and it never happened. And so as far as your credit is concerned, you have no judgment against you. And it's, much preferable, I think, to not to have a judgment against you.
What kinds of, you talked a moment ago about garnishing wages and that kind of thing. What other tools do creditors have at their disposal if there is a judgment against you, or if you default on a consent order? What are some of the things they can do in coming after you to get the money?
Well, one thing that's the law provides is that post-judgment discovery. And in that situation, they can require that you come in for a deposition and bring in all your bank records and
In other words, you have
all
to
your
tell them how they can
deeds.
get to you.
Right, and that they are required to come in and swear under oath, and sometimes, they're honest, and sometimes they're not. But if they don't come in at all, and this happens a lot, then you can get the judge actually to incarcerate them until such time as they provide you with that information. It's not exactly like debtor's prison.
I was about to ask you. I mean, we don't have debtor's prison anymore.
No, but if
so you're
you
not
don't-
being thrown in for owing the money.
For not answering the questions.
For not answering the questions that the creditor asks you.
And that happens a lot.
Oh, okay. Is there anything, Mr. Loeb, that you can protect from seizure by your creditors, or that you can make exempt from seizure by the creditors?
Georgia does have very limited homestead exemption, where you can file a document with the probate court in the county where you live, and certain items of your personal property cannot be seized by the deputy sheriff or deputy marshal for sale. Basically speaking, a creditor is going to use one of two methods to collect a judgment involuntarily from a debtor. One, if they know the bank account that the debtor has any funds in, they will file a garnishment against that debtor's bank account. If they haven't had any checks from that particular debtor before, they need the post-judgment discovery that Harriet was talking about to find out
They'll
what that
ask you,
particular...
and you have to tell them.
And the post-judgment discovery is based upon candor and cooperation, which is not always the case, particularly if you don't know where the debtor is and he's left the metro area and you just don't know where that particular debtor is. Secondly, you can file a garnishment on that particular debtor's employer, again, if you know where the debtor is employed. If someone's working for General Motors, it can be very easy. If they're self-employed, it's an extremely difficult situation.
One of the tools that you hear about, or probably, shown up in the movies and stuff, is, the creditor will go and seize your car or your house and make sure it's sold on the courthouse steps and get the sheriff to do that. Now, you hear about that a lot, and sheriffs can do that, but realistically, does that happen very often?
It doesn't happen much at all, because basically the creditor is not going to get the marshal to sell that particular property, quote, on the courthouse steps, end quote, unless it is free of any security interest. And most people have purchased homes, have a mortgage or deed to secure debt on it, so the sheriff is going to require that particular mortgage to be paid off before he's going to have the house sold. Most cars are financed or leased now. Leasing is a very good way now to get a very nice automobile and not have any type of basis for a creditor to go after that to seize the automobile. So you're going to have to pay off that car loan before you can get the car sold. And if you're talking about selling all the furniture and the bedroom stuff, you're going to have to pay the labor to get that household goods sent to a warehouse where it has to be stored for a couple of weeks.
Creditors don't like that
At the creditor's expense. Has to be advertised for at least 2 weeks at the creditor's expense.
So it doesn't happen very often.
So it rarely happens.
Okay.
It's a good threat, but it rarely happens.
Atlanta, hi, you're on the Layman's Lawyer. Go ahead.
Yes, my question deals with if you're purchasing a house and you already have a judgment on your credit report, can that be attached to the house that you're looking to purchase?
Okay, and the question is?
Can the judgment be attached to the house that you're looking to purchase?
Okay.
Even though you already have a judgment on your credit report.
Okay.
So the answer to that is yes. And it's going to be very difficult to purchase a home if you have a judgment against you. There's not many lenders that will loan the money to begin with, so I don't think you'd be able to do it. But even so, anything that you purchase would be subject to that judgment.
What he's going to have to do is, if he's got a judgment already against the gentleman before he buys the house, he's going to have to really get some type of seller financing where the seller just wants to sell the house and they're not interested in whether that particular buyer has a spotless credit record like you may face with Fannie Mae or some other type of government-sponsored or government-assisted financing.
Lawrenceville, hi, you're on the Layman's Lawyer. Go ahead.
Hi. My car was repossessed in December, and they sold it for quite less than what was the balance owed at the bank. And now, because my car was repossessed, I'm out of work, and I only receive unemployment. But they keep calling me, and I keep telling them, well, I don't have a job. So what are my precautions against that?
What are your options in trying to fight that? Yeah. Any idea, Mr. Loeb? Let's start with you.
Basically, if that creditor wanted to sue you for deficiency, that is the balance due on the contract, they're going to have to show if you filed an answer to the lawsuit. Remember, we talked about the need to file an answer to the lawsuit, that they sold that particular vehicle in a commercially reasonable manner. If they sold it through an auto auction, that may be deemed a commercially reasonable manner. If they put it on the front lot, that may not be deemed a commercially reasonable manner, and that's usually an issue of fact for whether it's tried before a judge or a jury. If that particular automobile or truck was also financed, they also have a duty to send a letter within so many days after the car is repossessed. And if they don't do that, that's also a defense to that particular lawsuit if the seller also did the financing.
So she might want to talk to an attorney and see try to get some of the details about how this was done, right?
That is, and then if it's been referred to a collection agency, send a letter to the collection agency saying, look, I don't owe this money. They did not sell in a commercially reasonable manner, or they didn't send me this particular letter they're supposed to, and get them off from harassing her.
As long as she raised the question about cars, let's pick up on that for just a second, because we were talking about, will they come and seize your assets, and we were saying that doesn't happen very often, except they do like to repossess cars, don't they?
If you get 2 consecutive payments behind on an automobile financing, there'll probably be a pickup order out on that particular car, particularly with the big companies like Ford Motor Credit or Chrysler Credit or GMAC. And you have to remember, in metro Atlanta, many times you need a car unless you live within close proximity to a MARTA line and you have a job within close proximity.
So that threat's a real serious one.
It is. To me, a car is just up there on a high priority with the house and utilities and the food.
Okay.
It's just something you have to pay. You can't do without a car.
Stone Mountain, hi, you're on the Layman's Lawyer. Go ahead.
This is pertaining to a foreign country, being sued from a foreign country. I've had judgment against me from France. Both times I was served with papers, it was by a federal marshal, and they were all in French. The first time I had them interpreted, and so I had a good idea what it was all about. I knew what it was about anyway. It was about an automobile accident that I didn't have, but they said it was my fault.
But you want to know what you can do?
I want to know, I guess I was told by a lawyer they have to come over here and serve papers in English through DeKalb County to do anything.
That's essentially right. The information he got was right. They have to domesticate the judgment in the county of your residence, where you live now, but it's not that difficult to do. Depending on how the courts prepare judgments in other countries, there's certain certifications that have to be made with respect to the documents from the other country and their judgment, but provided that can be done, then they do have to bring it to where you live.
And does it then become just like a lawsuit that was filed in DeKalb County itself, and the procedures are basically the same?
Yes, it does.
And if he loses, he'll have to just go through the same kind of thing that anybody else would?
Exactly.
Okay. Let's take a look now what happens if you are the creditor. Ms. Isenberg, we'll start with you. You want a judgment against somebody, and of course, they're probably not going to be too eager to pay you. So what are the tools at your disposal to go out and find out where the money is and how to get it?
Well, first you got to know who you have done business with, or know who owes you the money, and know where they are. And once you know that, then you can have a lawyer send them a demand letter, and if you send them a demand letter, then and they don't answer, then you can file suit against them. But it's the most important thing that people forget is to know who they're doing business with and where they are. That's the thing that I have the most problem with. Clients will give me, I want to collect this from, this particular debtor, and I'll say, well, who is it? Well, it's Joe, and he was working down here on the corner. Oh, well, that's all you know? Well,
that's all you know.
I can't help a whole lot in that, but there are ways to identify and locate people.
Now, you talked about a check, for instance. If you had a check from the person, you can get a checking account number, possibly, that kind of thing. Can you, and we talked about discovery, where you can have the person subpoenaed and at least get some answers from them. Where are some other places you can go to find out where the assets are?
Well, there's a lot of databases that different companies that do those kind of skip tracing and investigations, and they can find out sometimes through your Social Security number where you work, or through motor vehicle records.
How about the internet? I mean, if you're the creditor, can you try the internet?
Well, you can't really find assets to the internet, but you can find the people from the internet. Sometimes you can find that they own a home just by looking at the address. Once you've found, their person, if you will, on the internet.
One of the fears I think of a lot of creditors, and perhaps one of the defenses that debtors think of, Mr. Loeb, is, oh, okay, they're coming after my assets, I'll just give them all to my sister or my wife or whatever. Legal?
It may be legal. It's not very smart. You've got a couple problems. Number one, if you're insolvent and you transfer any property to a relative or spouse, that's what we call a prima facie fraudulent transfer. Very easy to set aside, and the person who receives the property may also be liable in punitive damages to the creditor. So it's not a very wise thing to do. The second problem with that, Dennis, is that you can't file bankruptcy within 1 year of that particular fraudulent transfer, or that's a basis to deny discharge on all your debts. Mm-hmm. So on something like that, you basically want to have the particular recipient or grantee pay you a reasonable sum representing the value of that asset. Whereas don't make it a gift, make it a bona fide sale.
Okay.
Or most importantly, go to an attorney who knows what they're doing before you sign that quitclaim deed or the deed for love and affection.
Quick final question here, Ms. Isenberg. If you give out false information to a creditor, for instance, who's trying to get discovery information from you, or if you pass bad checks to pay off the debt and it bounces, that kind of stuff, what can happen to you?
Well, it goes back to that same issue of providing bad information on post-judgment discovery. If you can, if you're sworn under oath that you're telling the truth, which you would do in a deposition, then you could be prosecuted for perjury or at least some kind of civil contempt.
We are out of time. I want to thank both of you for being with us. We appreciate it. Next week, one of the hottest issues of all, your health care. It's also one of the areas that's changing in our law. We'll take a look at it then. See you next week.
Major funding for The Layman's Lawyer is provided by the Georgia Civil Justice Foundation. The foundation publishes a free quarterly newsletter to teach you about our legal system. The foundation's telephone number is 404-522-2744. WPBA is not licensed to practice law or provide legal advice in Georgia. WPBA and the Georgia Civil Justice Foundation are not responsible for the views expressed or the information provided by lawyers on this program or on the telephone. This program is offered as a public service, and in all legal matters, you are best served by retaining your own attorney for private legal counseling. The lawyers appearing on this program and answering telephone calls are attempting to give general information on how to approach legal problems. Each advises viewers and callers to consult with an attorney of their choosing at a time when all facts may be fully disclosed, rather than by acting on the general information given in a brief phone conversation. Also, by taking your call, none of the lawyers agrees to represent you with your particular problem. If you would like a copy of tonight's Layman's Lawyer, please send a check for $35 along with your name, address, and the subject matter of the show to The Layman's Lawyer, care of AETC Incorporated, 740 Bismarck Road, Atlanta, Georgia 30324. Make your check payable to AETC Incorporated. Please allow 2 weeks for delivery.